And the topic is quite challenging because we talk about the personal data protection and artificial intelligence. So there are a lot of issues, and we try to figure out some of these issues during this presentation. First of all, data protection regulation back to the mainframes. Why back to the mainframes? Because this is the framework that we have in data protection. Data protection is based on the origin of the data protection is increasing concern about the risk related to the use of data. And in order to tackle this kind of risk, we adopt an approach that is risk-based, as you know, and is based on the idea that we have some fundamental rights that are in the individual dimension of data protection. And this is the framework that we developed over the years in order to provide some kinds of protection. So the idea is that there is a reaction in order to provide some safeguard to individuals. This is a kind of law that is based on processing the data and putting some safeguard along the data processing activities and focusing on fundamental rights and managing risk. What happens when we are in the artificial intelligence context? In the artificial intelligence context, we have to deal with a different kind of framework. A framework in which the data are collected in a different manner and moreover are processed in a different manner. When we talk about artificial intelligence, we talk about systems that are data intensive, that need a lot of information, and are able to extract new information from the data that are already collected. And this new information are used usually to predict the future, to understand the trends, and moreover, to have a focus not on individual necessary, but having a focus on groups. If you consider some application, for instance, credit scoring application, use of artificial intelligence in the context of recruitment processes, using artificial intelligence in predictive policing solution and so on, all this stuff is based on the idea that if you have a lot of data and you have a machine learning system, you are able to extract some inferences from the data to predict something about the data and about the people that are behind this data. In many cases, this is done without any specific focus on the identity of the person. So first, we have some problem with traditional idea of data protection, because data protection is based on the individual dimension. Rather than we focus here mainly on the collective, on the group dimension. We are interested in order to know if you are belonging from a specific group and classified in a specific group. We are interested to know if some people, if a group of people act in a certain manner rather than another manner. But in many cases, we may be not interested in the identity of these people. And this is true not only in the commercial sector, for instance, when you buy something online, but it's also true when we use artificial intelligence for social purposes. For instance, when you use artificial intelligence to support decision-making with regard the allocation of funds for education or for other kind of public interest activities. In this context, we have a framework that is not completely adequate in order to deal with these new challenges. For instance, in GDPR, we have still a relevant role recognized to consent and the notice and consent that is based on the idea that you are able to understand the framework in which your data are used and processed and to take a decision about that. That was true in the 80s, was true in the 90s, but it's no longer true now when we talk about data-intensive solution like the one that are used in the context of artificial intelligence. Because if I give you some information about the fact that we use an artificial intelligence tool that is based, for instance, on neural network, it's quite difficult for you to understand what is happening with regard to your data. Also because it's quite difficult for computer scientists to know that. Because a neural network is not so easy to understand how it works. We know only in a very basic manner that if there is an input, then there is an output. So artificial intelligence is basically a stupid intelligence, because it's something that we shape according to the fact that when there is some mistake, we are able to correct this mistake, and the system is able to learn. But it's not something like the human brain. It's not a machine that is able to have an idea about what it's doing. Is more like to some reaction that we have in animals and so on. So it's based on the fact that if something goes wrong, you give an input and the system memorizes this input and is able to perform better the second time. So in this kind of system that is quite complicated, the idea that you as data subjects are able to understand and to decide in a rational manner about what is happened to your data is not so easy to be affirmed. Another point is the idea of another key point in the GDPR, like in many other data protection laws, is the focus on purpose specification. Of course, purpose specification is important, but also purpose specification comes from the 70s. In a period in which, when you collect the data, was clear the purpose and the reasoning that you adopt in order to reach this purpose. But right now, with large-scale data, in many cases, the purpose is not defined at the moment of the data collection. In many cases, I collect a large number of data, then I try to extract inferences about this data. It means that I don't know exactly what is the final result of my analysis. Are the data that processor using different tools are able to provide me some information about the potential connection that exists in these data sets and so on. So in this sense, there is a purpose, but this purpose is not defined into details in a specific manner at the moment of data collection in many cases. But the purpose is redefined during the use of data. For instance, consider the data that are collected in a hospital to extract information about the well-being of the people that are in the hospital. You can extract information about specific disease. You can extract information about the disease that are created in a hospital due to the relationship that exists between the patients that are in the same hospital. So the cross kind of disease that exists in the hospital. In many cases, you are not able to predict which kind of outcome is expected from this kind of analysis. And it's the same, for instance, also with regard to a specific person. You can collect a lot of information about his or her health condition and then infer some information about the potential pathologies that were not expected at the beginning. So it means that the purpose that you have at the beginning is a specific purpose, but when specific is something that is quite broad. In this sense, in the GDPR, in one of the recitals of the GDPR, there is a specific reference to the notion of broad consent. Broad consent is a theoretical definition that was created by legal scholars in Oxford in order to address the challenges of large-scale data processing with regard to genetic data. In this case, it's difficult to know at the beginning the purpose of data collection because you collect genetic data and then you can infer different kind of information from this database. So in this sense, also this notion is not so easy to be applied in the existing framework or data-intensive system. As the same is for data minimization, because all these systems are based on large-scale data collection. Another point that is important is to figure out how we can react to this kind of framework that is quite different from the framework that we had in the 80s and the 90s, a more complicated system. In this sense, reaction is focused on transparency, and then we spend a few words about transparency and its limitation. On ex post remedies, it means sanctions, like in the GDPR. And in risk assessment and risk management. Of course, all this stuff are important because transparency increases the level of awareness and is also the basis for an adequate risk impact assessment. Risk assessment has a key role in managing the potential risk of artificial intelligence as well as the sanction. But all these remedies has also some limitation. For instance, with regard to impact assessment, right now we have several schemes about data protection impact assessment, also provided by data protection authorities, but these schemes are mainly focused on data management, data security. There is not a lot about the impact assessment in terms of impact on human rights and fundamental freedoms. There is only usually a final box in which there is the question, there is any kind of impact on human rights and fundamental freedom. And so and it's not so easy also to implement this kind of assessment because we need methodology. It's not something that you can do in-house by yourself. And the same is ex post remedies. Ex post remedies in terms of sanction are good, but as you know, in some famous cases like NSA case and so on, you have to know. In many cases, we know something many years after that kind of data processing activity was carried out. So remedies are good, but are not enough in many cases. And transparency. We discuss a lot about transparency. Right now, there's a lot of debate about transparency in artificial intelligence and many articles in the academia. But there are some constraints with regard to transparency, because what it means, transparency? It means the fact that you know that the interface as behind the interface there is an artificial intelligence tool. That's nice to know that I'm not speaking with a human being but with an artificial intelligence tools, but it's not enough in terms of safeguards and protection. It's only awareness. It's useful, but has a low impact. Transparency may be having access to the algorithms, having access to the information that were used to create the algorithm or to train the algorithm. This is very interesting, because if you have access to all this information, you are able to assess the quality of the artificial intelligence tool and the potential implication and risk. But of course, there are some limitations. First, intellectual property rights. Second, it's true that you can have access to these sources in some condition, but the access is only the first step. Then you have to check if this system that uses personal information, that uses an algorithm, has some bias, has some negative outcome on the individual and so on. To do that, you spend time. You know probably the famous case of Compass, that is a software used in the US court, and ProPublica. And ProPublica make an assessment of the Compass system and reaches some conclusion in terms of bias, again, in terms of racial bias. But, of course, you cannot imagine to have a ProPublica for each kind of algorithm application, or for each kind of artificial intelligence application. So we have to consider that assessing the bias, for instance, of an algorithm is time-consuming. And we need research to do that. The third point, is that in some cases it's not possible to have this kind of disclosure. For instance, if you use a predictive policing software, you cannot make a disclosure about the algorithm that you are using, because this is against the interest in using these tools in order to predict the criminal offenses. You can only provide some information about the general logic of the algorithm, but not the direct access to the information and the structural algorithm. So probably the solution in the middle, the disclosure about the logic of algorithm, is this more adequate answer in terms of transparency. But again, we have to further investigate a bit what it means, the disclosure about the logic. What is the logic? The input data that you use, the output data that you use. But in the middle, you have a machine learning tools, and so knowing the input and the output is not enough to understand how the output is obtained, and if there is something that in terms of bias in the middle. So it is also a technical problem in the sense. Knowing the weights and the variables that are used, knowing the architecture that we use, are all information that we can provide. But right now, there is a lot of work to do in order to reach the level of explainability. We talk a lot about explainability of artificial intelligence, but this technology right now is not so explainable, is not so transparent, and there are many constraints in this sense. And For this reason, transparency is a part of the solution, but is not the solution. Probably the solution is to have a better management of the risk related to the use of artificial intelligence tools. And to do that, we have considered that apart of some specific application, usually artificial intelligence in terms of impact on individual and society, artificial intelligence is used as a tool to support human decision making, rather than an autonomous artificial intelligence able to take decisions. Of course, there are some cases in which the process is completely automatized, for instance, in frequent trading activities in the financial sector and so on. But also from a human rights perspective, the most challenging aspect is when you use this tool to provide some suggestion to the human decision maker. And this is the point. In this perspective, it's important to realize that there is a sort of imbalance between the human decision maker and the machine in this sense, because the human decision maker have no chance to spend a lot of time in order to analyze for a second time all the data that are processed by the machine. Moreover, there are problems in terms of freedom of the decision maker and ability to take a decision without any risk, for instance, to be fired or something like that, because it took a decision not consistent with what was suggested by the machine, and the outcome was negative. And so probably a passive attitude, more in line with the suggested in machine, is more conservative, is more safe for the human decision maker. And in this context, the risk is mainly related with bias, and the focus on bias, so the focus on the potential mistake in analyzing the situation, so taking wrong decision, also figure out how the main issues is no longer data protection only. We talk a lot about data protection and artificial intelligence data protection, but in terms of safeguard interests and rights, when you consider artificial intelligence, you consider a technology that have several applications that affect, for instance, your freedom of speech if you use artificial intelligence to select the content in an online environment in order to remove, for instance, the content that are not consistent with the legal framework or the terms and conditions of the platform. Can impact on freedom of movement, can impact on many different kinds of rights that we have. In this sense, I think that we have to adopt a broader perspective, not only focus on data protection, but considering that data protection is something that enables other rights. Now, a correct manner in processing data is a safeguard in order to be to have a better protection of other rights and fundamental freedoms, mainly in a context in which artificial intelligence and data-intensive systems take a lot of decision about the citizen and the communities. In this sense, it is important to consider the potential bias, and the bias as listed in this slide may have different kind of origin, not necessarily the data set, not necessarily the algorithm, but also some human bias, because we talk about a machine and the impact of the artificial intelligence as something that is only a technical tool, but beyond artificial intelligence we have people that created this system. In many cases we have computer scientists that created this system, and voluntary or involuntary they transmit some values. Okay, for instance, there was a famous case in which an insurance used a tool to detect the use of cars and consider as a negative input using the cars during the early morning, because during the early morning many people come back from after having a party, and so with a lot of alcohol and high possibility, high risk in terms of accident. But this was a sort of representation of the society of male artificial intelligence developer with a good level in terms of income. And in this representation of the society, for instance, the developer did not take into account that there are also people that take the car and the 4 in the morning in order to go to work, and they living outside the city, going to the city, working in the city, and in many cases making a work that is not so well paid. And in this sense, the high rate that was related to this kind of use of the car is not consistent with the risk. But this is an example that makes explicit how these tools that are artificial intelligence, we classify as machine learning, something that is technical, as also a sort of representation of the people that created these tools. In many cases, the people that create these tools are not the legal and the social background to understand the consequences of their decisions. And in this sense, the risk assessment is very important in order to avoid the decontextualization, both of the data and the system. What is the problem of decontextualization? The problem is that if you consider the data per se without considering the social consequences or the other elements related to the social dimension of data, for instance, you create a wonderful algorithm that is able to make a sort of ranking of the schools based on the performance of the students and provide the funds to the best schools without taking into account, for instance, the social issues related to the different places of your country that necessarily affect the level of performance of the students. So this is the risk, the lack of attention for the context in which we collect the data, and the focusing only on the algorithm, on the artificial intelligence tool, and not what is behind and around. And so in order to address this kind of challenges, there are some solutions that are discussed at a different level, at European and not only European level. And the main driver in this debate are the focus on proportionality and the focus on responsibility. Proportionality with regard to the use of data, but also proportionality with regard to the use of artificial intelligence. And responsibility is accountability are two very important roles. It means that if you create a system that have an impact on society in a certain manner, you have to consider your role in that game. In this, as a consequence, has an important relevance of risk management, risk assessment. And there are two important points also: transparency, that we already mentioned, and participation. Participation, because when we consider some tools that have an impact on society, we cannot imagine that these tools are developed by companies or by a small group of computer scientists without any kind of chance to give voice to the people that are potentially affected by this system. So there are also ethical issues related to this topic. There is a lot of debate about ethics and data protection, ethics and artificial intelligence. I don't want to spend a lot of words about that. I want only to remember that ethics and law are not the same things. What is in the law, of course, has some roots in the ethics, we hope so, but is something different from what is a mere ethical suggestion. The law is, if you want, a selection of the ethical principles. We give a shape through the law of this ethical principle, and we cannot misunderstand the role of the law and the law of ethics. Ethics is very important to complete the picture, to cover the gaps in which we have not legal provision, to give advice in order to better address new challenges or some social decision. For instance, having a body scan or having extensive forms of video surveillance in a city are something that might be consistent with the legal framework, but not necessarily consistent with the ethical and social framework of that specific population area on country. So this is the role of ethics, and unfortunately, in some cases, we misunderstand this role. So. What is the state of the debate? There are many documents on that, but some documents are already adopted. In this sense, the Council of Europe has adopted the guidelines on artificial intelligence. The the group of the data protection authorities that in its last annual meeting has adopted a declaration that is not the final version because it's open to the debate. The European Commission high-level group of experts has also adopted a draft on artificial intelligence ethics. And the DPS starting a debate with a document adopted last year on data ethics. And then we have a lot of documents adopted by companies, groups of experts, categories, and so on. Due to the different states of the art of these documents, I mainly focus on the document adopted by the Council of Europe because it's the first document adopted, finalized at international level. And in this sense, of course, the Council of Europe has an approach that is based not only on data protection, but fundamental rights. And this is the approach that we have also adopted in the previous document on big data. And it's important also to point out that the focus is not only on rights and freedom, but also on the ethical issues that are part of the risk assessment that is suggested to carry out. But these guidelines are guidelines that want to be very practical, so focus on the role of the different players and the role, for instance, of the developers. With regard to the developers, we suggest to adopt a value-oriented design. It means not only privacy by design, but human rights by design, hopefully. So focusing on how you can embed in your system the values and the rights that are recognized at international level in the Charter of Human Rights, and also the ethical values that are consistent with the specific context in which you want to apply the artificial intelligence tools. To do that, an important role should be recognized to the risk assessment, because it's by means of the risk assessment that you are able to check the impact on this kind of rights and also on this kind of values, more in general speaking. And another point is that we have to focus on data quality, as we usually say. So we have to focus on the nature of the data, the origin of the data, the quantity of the data that we use, because in many cases an approach that is based on extensive collection of the data, but are not necessary it's not necessary to have so much information in many cases, and the risk of the contextualization that I mentioned before. We have to be aware about the fact that data and the algorithm are not the only focus of our reasoning, but there is something also around. Another important point that we have pointed out in this guidelines, is that it's important to have a broader approach involving not only the developers, so the experts in terms of computer sciences, but also other kind of expertise. In this sense, the role of committees of experts, mainly with a social background, is very important in order to have a better knowledge and awareness of the impact of the tools that are developed to be applied in our society. And also the role of participation, as I mentioned before, the role of participation that, for instance, in the GDPR, in data protection impact assessment, is not so relevant, unfortunately, but we suggest to have a better manner to assess the risk through a participatory approach. It means that you cannot only do your data protection impact assessment inside the company, but you have to actively engage the community that are potentially affected by your decision. And this is positive because this creates a sort of co-design, and is also in line with the suggestion of the United Nations that say that the participation is important also to better understand the problem and to better detect the challenges and the consequences of our decision. Other points that are important is the freedom of choice. So you have the smartphone, you have the smart fridge, you have the smart home, but maybe you have also the right not to have all these smart technologies, but you want to have a stupid fridge, a stupid phone, a stupid home. And this is an important aspect in terms of choice. If you consider your smartphone, when you switch on your smartphone, you are immediately connected. With the old-fashioned telephone, you are not connected until you make the call. So it's very important also to drive technology and not to be driven by the technology. And in this sense, we provide also some guidance with regard to the role of the policymaker. The policymaker have an important role, for instance, in public procurement, because in public procurement they can fix some specific provision in order to have a better development of artificial intelligence, more value-oriented. And we consider also that they have an important role in what we call the vigilance, so the algorithm vigilance. Algorithm vigilance, it means that when you create an algorithm, when you create an artificial intelligence tool, you cannot say, okay, I put it in the market, I make the test phase is okay. No, it's like the drug. When you put a drug in the market, you have to check the side effects, because the side effects on a larger scale are different from the side effects in the test environment. In this sense, we have to create a sort of vigilance about the application of the artificial intelligence tools. And finally, due to the fact that artificial intelligence may have an impact on many different kinds of application, we have considered that we have to start an effective dialogue between the different authorities. We talk about the idea of having an artificial intelligence authority, but I think it's very difficult to have an artificial intelligence authority, because it means that we no longer need data protection authority, competition authorities, communication authorities, and so on, because all these sectors are potentially affected by the use of artificial intelligence. Probably, like suggested by the DPS, we have to have a better dialogue between the different authorities to consider the effect of the use of artificial intelligence tools that may impact on different kinds of fields. And this urges these authorities to have a common strategy. In the presentation, you have more details and more stuff for reflection, like in the dossier, but it was the approach of my teaching nature to give more and discuss less.
Thank you very much, because this is a very interesting perspective. So.